The very word secrecy is repugnant in a free and open society, and we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. We decided long ago that the dangers of excessive and unwarranted concealment.
Mr. Risner?
Yeah, Judge.
I asked Mr. McLaughlin last hearing whether the city was going to pay a fee award for the individual defendants, and he said that it was, I believe. And I'll ask you a similar question in the sense, have you billed all of the fees that you're requesting?
Do I understand what?
Have you billed your client for those fees?
Well, my client has seen the fee list, but if you're asking, have I sent a letter to Cecilia Cruz and said fork over $100,000? No.
No, it's a coalition, correct?
It's what?
It's a coalition that has been paying fees, correct?
The coalition has paid some fees initially. The problem with representing a group like this is that the city that has lawyers and, umpteen resources knows that they can grind the individuals and drive up the costs and prevent the public from successfully proceeding. So it's true that they've not filed that, but they have had a fundraising effort.
Okay.
But
Right,
it's
so-
nowhere near the amount of money that is involved with the fees, I can tell you that.
Okay, you've answered my question, so I'm sure you want to have some time to reply, so why don't you go ahead and reply to Mr. McLaughlin if you wish.
Yeah, there's, actually, one thing, I did, apparently $12.20. I'm not sure how that got out there, but, I think it was because of subpoena, maybe a check was written, and if you hadn't cashed it, that's fine, it wasn't certain. But, look, my position is clear that, I filed an attorney's fee request because Your Honor said file one by December 13th. Fees are an important issue, so I don't want you to take it wrong, but this case, it would be a travesty if, because they made misstatements to the court, that my client can't now reopen the case and can't find the documents that were requested initially. You read the whole thing, it wasn't just the one paragraph I read. It was talking about all city departments, entities, personnel, feasibility, financial impact studies, blah, blah, blah. It is absurd, the suggestion of the city that there was anything limited or narrow about the request or the trial. I've heard lawyers say in court that each party, you can't have your own laws and you can't have your own personal facts, and you can't have your own language. We really need to use the English language in the way that it's ordinarily spoken and understood. And the legislature said, by statute, since statehood, that if you ask for public records, they shall be turned over. And we asked for records, and none of those have been voluntary disclosures. They're required, they're mandatory, and it's mandatory required that they be prompt. It's not a situation, if we come across some records, but we'll give them to you when we find them. We're still looking. Right now, you hear that, we're still looking. or when they came in last time and said, wow, here's a list that, that Tina Pacheco put together, and, you know, we've only had 3 weeks, but we're a third of the way through that list. There's nothing voluntary. There's nothing limited about the lawsuit. It said, we want the records requested. Frankly, there's nothing particularly limited about the city's response May 24th. I can advise you there's certain other records that may be within the scope that we're withheld. And then we have a trial, and then, you know, the city comes back to this, it of course wasn't just in the, in that July 8th. We put in other records, and Your Honor heard repeatedly at this trial. We've turned over everything. We've turned over everything. And then, it's an interesting thing with the sealed envelopes. You know, the city says, we may have something that's attorney-client privilege. And sure enough, they found an attorney-client document. Now, I don't know what's in it, because, you know, as, you know, you were before talking about if you're dealing with a corporation or something, you know, when those kind of things, lawyers file a privilege log. So we have this document, it's privileged, it was on this and such a date, it was a meeting with this and that. I have no idea what was put in a sealed envelope. And I didn't argue that. Sure, okay, so they got one. They found a attorney-client privilege thing. But it sure as heck wasn't what this case was about then or now. We don't deny that there is somewhere in City Hall attorney-client privilege documents. But what we do know in City Hall is that there are hard copy files. Kaselemis described it. He said other people have those files. It's the kind of things you ordinarily see in these kind of deals. That's stuff that they were required to turn over. And they can't come in and give false statements and say, aha, we got it. We put something in there that really was attorney-client privilege, and we said all these other documents were because we were thinking, in spite of the English language used in the request, we've decided that it's only about this one little thing. And so, there you go. Look, I don't think attorney-client, I don't think attorney's fees should be the issue today. Attorney's fees are ordinarily awarded at the end of a case. Now, if Your Honor wants to award fees now and open the case to give us a fair shot to force the city to get the rest of the fees, the rest of the documents over, I suppose that's reasonable, but otherwise it didn't. It isn't a situation where they lied, they win, shut the door, here's your check, go on, and we don't get the documents. I was hired to get the city to respond to a request for records. They didn't do it, and they haven't done it. The door can't be shut on that. That's the whole point of 60C. And as I cited the case, it's even inadvertent. You just can't do it. You can't come in and say, you believed us, we win, now we find out there's stuff out there and other stuff, and we got a great deal. Just keep sending us things. Just keep telling us what it is you haven't given us. I gave you a whole list of all of those people that are involved. Every one of them's going to have a file.
It's Exhibit 11, right? The one
Yeah.
admitted today.
Yeah, and you have evidence. The evidence is from Kaselemis. Yes, there's calendars. Yes, there are all of these things. But we can't be in a box where we have to rely on the city saying, oh, I talked to this person, I talked to that. Turns out nobody in City Hall makes notes, nobody keeps records, nobody does this. It's kumbaya up on the 9th floor. That's not how it works, and they haven't earned the trust where we need to rely on that. They need to get the documents, and if they turn it over with us, I suppose, maybe they don't have to take so many depositions, but I think in this case, I really need to get some people under oath and say, what documents exist? Did you turn those over? Where are they, so forth, and so on. So that's the heart of this case. I will mention on the bad faith issue, it's sort of interesting where, you know, the city argued in terms of the original 59 motion that I was required to put on bad faith evidence during the trial. And of course today, they've emphasized that bad faith is not a requirement for public records laws. I fully agree with that. That's why during the trial, you know, it's not an issue to put on during the trial. Afterwards, it can be an issue, and it absolutely is an issue for 12-349 and 350, the additional requirements. That talks about bad faith defenses. That talks about a situation like here where the city of Tucson, with their experienced lawyer of 31 years, comes in and argues to this court that you've got no subject matter jurisdiction to hear a public records request. It's just amazing the defenses that they put out. You've got no subject matter. Now, oh, well, this is voluntary. These are all invented stuff. And I was pleased to hear him mention public policy. Public policy is very important here. And it's the public policy that our public servants follow the law, turn over documents, and do it promptly. This isn't like dealing with a corporation, because a corporation, records have to be relevant to issues. There's a whole world there. Public records, no relevancy requirement. And in fact, our public records include other matters that are in the office. Our case law says there's no difference between those. That's all public records that you've got a right to, public records or other matters that are in that office. So all of the paper stuff that we've asked for, we absolutely have a right to, and all they can do is look at them, and if there's certain privileges, identify the document and what the privilege is, or redact, you know, limited information. You know, if there's a policeman's home address and they, you know, redact it, that kind of stuff. Otherwise, they turn it over, and they're obligated to do it, and they must do it. And attorney's fees ultimately should be ordered because of all that. But this court should grant the 60C motion because the city has been not following their required procedures. They have the duty, if documents do not exist, all the evidence is that it does, but if it does not exist, where are the declarations? Where's the affidavits? Where is their duty to put on proof? They're not the first one that has come up with this, show us what's their stuff. They need to put on evidence to say who looked and where, and that it's not there. Thank you.
Thank you, Mr. Risner. That concludes the hearing on the pending motion for attorney's fees, pending motion for relief pursuant to Rule 59, and pending motion for relief pursuant to Rule 60C. All of those motions are under advisement. I'll issue a written ruling. Is there anything else we need to discuss this morning?
I don't have anything to say.
Thank you very much. Have a good day.